Welcome to our guest takeover. In this episode, my learned friend will help us unpack some real-life family law scenario. Here's the scenario they'll be walking us through. Busola and Dami relocated to Canada in 2020, and at that time, they had been married for 7 years. They purchased a matrimonial home in Mississauga, which they own jointly. Their marriage has since broken down, and they are now considering separation with the intention to proceed to divorce. As a family law lawyer, what steps should they take to ensure that their jointly owned matrimonial home is properly addressed and dealt with in accordance with the law? To help us unpack and understand the practical steps separating spouses should take, Ibukun Ogunfuwa from Dunnis Law will walk us through how couples in this situation should approach dealing with their matrimonial home and why getting it right early matters.
Thank you so very much, Bumi. First of all, I would like to say that on this episode, we're going to be giving legal information and not legal advice. So everything we're going to be saying here is just legal information as to how this kind of scenario can be dealt with. The first thing that jumps to mind from this scenario is that the parties, Busola and Dami, are considering separation. Likely they haven't made up their mind yet. But that brings us to the point that they need to make up their mind as to whether or not they want to separate. Because at every family law matter, the date of separation is very critical. In relation to the question, how to deal with their matrimonial home is dealt with, is given special statutory treatment under the Ontario legislation. Regardless of whoever owns the house, it doesn't matter. The fact that one person owns it or that they jointly have title doesn't matter with matrimonial home. So it is treated very specially, and that's what the parties need to understand. Matrimonial home is mostly the most valuable assets, or we can call it the most emotionally significant assets that a family would have. And so it matters a lot, especially where there are children involved. In this scenario, we're not sure whether children are involved. But when children are involved, it makes it even more difficult because that is the primary residence of those children. That's the only way they know as their house. So Busola and Dami needs to proceed to take legal advice as quick as possible so as to protect their interests in the matrimonial home. They have to avoid any unilateral action. They have to ensure that the property is dealt with fairly, lawfully, and they conclude every financial affairs that deals with this property. Mind you, the matrimonial home is not the only property that a family may have. They may have other things. They may have houses, they may have pension, they may have so many other assets. But like I said earlier, the matrimonial home is always treated significantly. The legislation that would help in Ontario or in Canada with relation to matrimonial home or family law matters is what we call the Divorce Act, because these parties are married. We know that they were married from Nigeria before they came to Canada. So they married 7 years ago. So the laws apply. The Divorce Act of Canada would apply in this scenario. But because they live in Ontario, the law would also become significant to them, and that's the Family Law Act, which is local to Ontario. Each spouse, Busola and Dami, have a right of possession by virtue of the fact that they jointly own this property. Both can live in the matrimonial home, even though they are separated. So this is the question. They are both separated, or they are both assuming now they have decided we want to separate, and they've chosen a date of separation. They want to decide who would stay in this house. It may not be conducive for both of them to stay in the house together. They have to decide who should reside in the home, whether it's going to be Busola or Dami. If they are amicable, they can agree among themselves and say, okay, Dami, you just stay in the home, assuming they have children, and Dami is, or Busola is mom. They can say, Busola, just remain in the home. So at that point, Busola has possession of the home. However, where there are safety concerns, there are issues of domestic violence and all of that, one party has to reside in the home. So they have to be what we call a claim of exclusive possession, and they can go to court to start a family law matter in order to get a claim for exclusive possession. Okay, now let's say that they agree that Busola stays in the home. It shows that this is just a short term. Busola has exclusive possession of the home for the meantime. Now they have to look at the larger picture, because they have been able to successfully determine their living arrangement. Who will remain? Busola will remain. Okay, Busola is remaining. What about payment in terms of the mortgage payments, the property taxes, utility bills? Who is going to take care of the carrying cost of the home? This is another question that both parties need to decide on. And these costs are mostly called, like I said, the carrying costs of the home, and they can be dealt with by way of post-separation agreement if both parties decide that one of them should take it. So post-separation agreement, I will still come to that bit as we go on. If they decide that Busola should stay in the home, then Dami can claim what we call occupational rent, since it's a jointly owned property. In Ontario, occupational rent is discretionary, and it can be rarely awarded if the parties go to court, as it is often set off by the occupying spouse, in which case Busola paying the mortgage, taxes, the property taxes, the utility bills, the household expenses. Or if she's receiving support and she's using the support payment, if they have children or even spousal support, to pay for the carrying costs of the home. So neither Busola or Dami is allowed to sell this property. Neither of them is allowed to transfer the property. Neither of them is allowed to mortgage the property unilaterally. And now let's go back to the valuation date. Remember I said earlier that they have to decide whether they are separating, and they have to note that date. They have to communicate. In fact, it's always advisable to communicate that date in writing to the other party. Say January 1st, 2026, we are no longer together as a couple. The valuation date is very, very important, because it helps us to analyze what the market rate is as at that day of separation. It also helps us to establish what the outstanding mortgage balance is, and also determine the equity in the home. There is a principle under family law called the equalization of the net family property. Like I said, matrimonial home is one of the parties' assets. They could have cars, they could have a cottage, they could have pension, they could have so many different other assets that they own. So the matrimonial home is part of, it's part of the item that would be, that can be included in their net family property. Each party needs to calculate the net family property and exchange what we call a sworn financial statement, which is giving both parties full financial disclosure of what they own, their assets, their liabilities. Sometimes they're excluded properties. If they own a property before marriage, then it could be excluded. But if that property that they own before marriage becomes their matrimonial home, like I said, the matrimonial home is treated differently. So in that light, whoever owns it doesn't matter at that point, whether or not Busola owned it before marriage, because it's different, it's treated separately. But if they had another house, for instance, a cottage before marriage, then it could be excluded from the net family property value. Usually, it's always important to contact your family law lawyer to assist you with drafting your financial statement and ensuring that full financial disclosure is exchanged. Now, the options that they have for that house, remember it's their matrimonial home we're talking about here. They can either sell that house, they can transfer the title to each other. So Busola transfer her own title to Dami. So meaning that Dami would buy out Busola's rights in the house. And they can decide that, because we have children, we just want them to finish college. We want them to finish high school. After high school, we'll decide whether or not we want to sell. So in order to have that kind of arrangement, they need to have what we call a separation agreement drawn up. Now, separation agreement is usually advisable if parties are amicable, if they're willing to negotiate, mediate, or collaborate on all the issues, including the matrimonial home issue. If they are not amicable, then litigation will be the best part. And even when they're actively in litigation, they can still proceed to negotiate along the lines, because it's a long haul to go into trial in family law matters. So they can still, mediate or negotiate even while they are in court and trying to litigate. If they are getting a separation agreement, if they are amicable, then one of the parties needs independent legal advice. So say they're amicable, Busola decides to get a lawyer to draft a separation agreement, then Dami needs independent legal advice, so that whatever is drafted and given to him, he reviews it with his lawyer to ensure that it is in accordance with his own wishes and his own rights. Litigation in Ontario is usually brought when there are property issues or divorce matter. Remember, in the scenario they had talked about, they are contemplating divorce. So if they are contemplating divorce, the right court to go, if they have to litigate, would be the Ontario Superior Court of Justice Family Law. If there are sometimes parties, we've had scenarios where parties would be about to refinance their home. They have to see how they can arrange mortgage financing to ensure that whatever they decide in terms of their separation agreement would be taken into cognizance in their mortgage refinancing. If it's the fact that they want to equalize, they can decide that they can actually decide, okay, you know what, just give me the equity in the home. Some people would decide, oh, again, remember that matrimonial home is treated separately in family law matters in Ontario. They can decide, we don't want to equalize, but we want to share the equity in the home. So we're going to treat the matrimonial home separately, and then we're going to all other assets. We don't need to equalize all other assets. We're just going to divide the equity in the home. And the last thing that they need to consider is title transfer. So they need to update their title so that compliance is ensured. In conclusion, we all need to remember that matrimonial home receives high protection in family law in Ontario. Parties must address possession, they must address valuation, they must address equalization and disposition of the home carefully and in compliance with the Family Law Act and the Divorce Act. Early legal advice and structured financial disclosure are essential to avoid any issues and to ensure a fair outcome. Pretty much the summation of my advice to Dami and Busola. They need to treat this seriously. They need to decide exactly when and how they want to move forward with this separation. If they're really going to separate, they have to act fast in terms of ensuring they ascertain the date of separation. Even if they separate today, say they're separated January 1st, they have a period where they can still reconcile. If they reconcile, it nullifies that date of separation of January 1st. So they need to ensure that they ascertain that date. That date is very critical. Thank you.